Okay.
Good evening, a warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Honorable Mr. Justice K N Phaneendra, former Judge, High Court of Karnataka. Sir, we are honored and privileged to have you with us today. Welcome to the webinar. Though His Lordship requires no introduction, it gives me immense pleasure to introduce today's speaker, Honorable Mr. Justice Koratagere Narasimhamurthy Phaneendra, son of Srimati K N Sunandamma and Sri Narasimhamurthy. His Lordship obtained his graduation from Government Science College and law degree from Vidyodaya Law College, Tumkur. His Lordship enrolled as an advocate in the year 1985 and joined the office of M.S. Rajendra Prasad, former Judge, High Court of Karnataka. His Lordship as an advocate mainly practiced on criminal and civil side. His Lordship worked as an assistant professor of law in Vidyodaya Law College. In the year 1998, His Lordship joined the Karnataka State Judiciary directly as a district judge. His Lordship served as an additional district and sessions judge in Bengaluru, Shimoga, and as principal district and sessions judge at Haveri, Udupi, and Belgaum districts. His Lordship also served as the Chief Secretary to the Honorable Chief Justice. His Lordship served as the Director, Bengaluru Mediation Center, and Principal Secretary to the Government of Karnataka, Department of Law, Justice, and Human Rights. Later, His Lordship elevated as the Judge of the Honorable High Court of Karnataka and retired in May 2020. Sir, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you, sir.
Thank you very much, Mr. Trivikram. And I'm very thankful to the Advocates Association Bengaluru for having provided this opportunity to share few of my thoughts with reference to the subject which we are going to deal with today. That is the salient features of the POCSO Act with reference to the present scenario. So before adverting to the Act itself with reference to its salient features, we have to understand some background and history. Why we have to enact such a drastic enactment in our country. According to me, we must be ashamed of ourselves because we are forced to introduce such enactment where there is no safety to our children. Even from the domestic people who are residing in the same shared house, the children are not safe. And the children are not safe with the environment we are having, the surrounding people we are having. Therefore, to safeguard the interest of the children who are the better citizens of our country, future of our country, the enactment has to be brought into force. According to the census data from 2011, it shows that we have 472 million children below the age of 18 in our country. The protection of children by the state is guaranteed to Indian citizens. Therefore, we must understand that we are also adhering to the UN Convention with reference to the rights of the children. We have to look into the previous laws. Why technically we have to bring this law into force. We had earlier the Child Marriage Restraint Act, even today it is in force, and Children Act, and most of the provisions under Indian Penal Code, particularly Section 375, 376, 354, and 377, were found to be inadequate. As we see, Section 375, it does not protect the male victims or anyone from sexual acts penetration other than the traditional peno-vaginal penetration. So except Section 375 stating that what is the peno-vaginal penetration and the accessories to that particular act, there was no meticulous definition with regard to the other type of sexual offenses that may be occurred during the daily lifetime. Section 354 of Indian Penal Code, it in my opinion lacks a statutory definition as to what is meant by modesty. Section says that it is outraging the modesty of a woman. Whether women include child, what type of modesty that requires to be violated by the people, etc., has not been in detail meticulously dealt with under the definition under Section 354 of Indian Penal Code. Further, Section 377, another provision which is referable to unnatural offences. There also, the definitions have not been completely given. Only it appears one type of offence we can recognize from such the definition given under Section 377. So if these provisions are looked into, and even under the Children Act and Child Marriage Restraint Act, the children are not so much protected. The penal provisions are so meager. Section 354 is not punishable with serious punishments, though the offense appears to be very vigorous in nature. So therefore, the lawmakers found that, and in order to bring home the offenders into the books, it required a larger interest of the society and children. It required the parliamentarians to bring this enactment to safeguard the children. The object of this particular enactment is more proficiently to curb the heinous sexual offences and offences particularly done against children. So far as the adult members are concerned, adult offenders are concerned, the Indian Penal Code and other laws would take care of that. But so far as the children is concerned, though it has taken care of to some extent, but it was not so much as expected by the legislators. Therefore, they wanted to introduce a new enactment which came into force in the year 2012. This act is nothing but a comprehensive combination of all types of offences on the basis of imagination and on the basis of a report submitted to the parliamentarians and on the basis of analysis of the entire types of offences prevailing in the country. This enactment was made so comprehensive that each and every type of minor and major offences are clarified and defined in the particular enactment. Even this enactment goes to the extent of defining what is meant by harassment. Harassment is also now made punishable under the provisions of the POCSO Act. Though the harassment in the ordinary sense, except under Section 498A, is not made punishable, there, whether it is children is included, or if the harassment is given to the child, what should happen? 498A is also not so sufficient in order to bring home the guilt of the accused. Further added to that, the harassment defined under Section 498A in the nature of cruelty is applicable only to certain people. And if the such section cannot be applied to the persons who is outside the purview of that particular provision. Therefore, in order to bring home or in order to meet all the contingencies prevailing in the country, this new enactment was sought to be introduced. Further added to that, there should be a speedy remedy to the children who are affected by this particular offences enumerated in the enactment. The investigation, how it is to be done, who has to do the investigation, within what time investigation should be completed, within what time charge sheet has to be filed, within what time the evidence of the victim has to be recorded, and within what time the evidence before the court shall start, within what time it should be concluded. Everything, if you go through the enactment, it is a speedy remedy which is made available to the persons who are affected by these offences enumerated under this particular act. The act also provides establishment of special courts. Why special courts are required and who has to head that particular special court? An experienced man who is having sufficient professional knowledge, who is acting as a district or sessions judge, who is going to head that particular special court. The objective of enacting the POCSO Act is also to protect the children from various types of sexual offences and to establish the speedy remedy to them in all the corners, and also to safeguard their interest as to how they have to be treated by the investigating agency and also the court while recording the evidence, etc. Separate procedures have been formulated in this particular enactment. Moreover, this enactment, if we see the salient features, that it creates a gender equality. It is neutral both to the male child and a female child. So far as the modesty of woman is concerned under section 354, it was only concentrated with regard to women. That is, modesty of woman is specifically mentioned therein. No child or what should happen to a female violates the modesty of a male child. So therefore, irrespective of that, whether the child is a male or a female, or the person who commits the offense, whether he is a male or female, irrespective of that, the act was made applicable to one and all who comes within the purview of this enactment. One should also bear in mind that this enactment is virtually in addition to all the other penal enactments in the country. As we know that there are several enactments in even 376, 377, 375, 354, and other offences which are recognized under the Indian Penal Code and other law for the time being in force, which are projected for protection of the children. Those also taken into consideration, they are not at all disturbed. In addition to these laws, this particular enactment has been brought into force with regard to mainly concentrating the environmental benefit to the children at large. And the cumbersome procedure contained in the Criminal Procedure Code and also in various other enactments, the lawmakers have taken into consideration with reference to the recording of the evidence and recording of the statement of the victims, how it should be recorded, when it should be recorded, where it should be recorded. Everything is prescribed under the enactment itself. Therefore, to make the procedure child-friendly and to provide speedy remedy, the special procedures have also been given under the enactment. So with this particular background, the previous history with reference to this POCSO Act, now we have to go through what about the contents of this particular document, that is the POCSO Act. I may not be able to go through each and every provision in the enactment, but what I will do is that I will go through each and every chapter. What is important in that particular chapter we can discuss, and thereafter if any question arises, we can deal with those questions if it is referable to any other provision under the Act. The chapter 1 of the POCSO Act, which covers the definitions. The definition clauses covers what is meant by offences, sexual assault, aggravated form, what is meant by aggravated form, and the definition of a child and domestic relationship, and especially what is meant by shared household and religious institution, etc. So other provisions so far as the aggravated penetrative sexual act, sexual assault, sexual penetrative assault, and sexual assault, harassment, etc. have been defined in the separate provisions in the Indian it's enactment itself, while defining what is meant by an offense which falls under such provisions. But apart from that, in this particular chapter, what we have to understand is that the child is defined. Who is a child? The much importance has been given to the age of the child so far as this enactment is concerned. Prior to go to that particular definition of the child and how the Supreme Court and other courts have tested the age of the child, how it is to be determined, etc., we have to understand domestic relationship is defined. You see, in order to bring home the offenses that may take place inside the families with reference to the domestic relationship, for example, brother committing offense against sister, father committing offense against his own child, mother committing the offense against the son, it may happen in the days to come. It is said that we can find a bad father in the world, but not a bad mother. But we don't know, that may also happen in future. Therefore, in order to cover that also, everything, domestic relationship is explained. As per domestic relationship definition given, under the Domestic Violence Act, the same definition has been reinforced in this particular enactment. That is, a relationship between two persons who live or have at any point of time lived together in a shared household when they are related by consanguinity, marriage, or through a relationship in the nature of marriage, adoption, or family members living together as a joint family. So therefore, all the joint family members are covered under this domestic relationship. If anybody commits any offense inside the domestic relationship, this particular definition covers that those persons are also liable for the penalty under this particular provision. So religious institutions are also defined. As per section 2F of Religious Institution Act, it means an institution for promotion of any religion or persuasion and includes any place or premises used as a place of public religious worship by whatever name or designation known. So if the religious institutions are used or for the purpose of persuading a child or for the purpose of committing any offense against a child or abetting any offense for the purpose of committing a offense under this particular provision, you might have come across, there are various educational institutions, religious institutions, inside which some offenses have been committed under this particular enactment. Therefore, in order to cover those places, premises, it may be a mosque, it may be a church, it may be a temple, whatever may be the religious institution which are defined under that particular enactment is also almost reiterated in this particular enactment. Shared house is also defined. It means a household where the person charged with the offense lives or has lived at any time in a domestic relationship with the child. You see, if a person today he may be living in that particular house, tomorrow he might have left that particular house. He may say that I am not living there. But shared house, if the definition is attracted, then at any point of time he lived there and he has committed any offense with any child in that particular house, shared house, then also the offense is attracted. So therefore, the definition, apart from the giving definition to the offenses committed, apart from that, some extra definitions have been given and extra institutions have been added to that particular enactment, so that wherever the child goes, whether it goes to a church, temple, or any religious institution or educational institution, or to a household, shareholding house, or resides in a joint family, everywhere the child goes, if the offense is committed, those offenses are also covered under this particular enactment. Therefore, by means of giving these definitions, the places where the child visits is so enlarged that it will cover almost all the places where the child goes. So in this background, the child definition is also given under the enactment itself. Who is a child? Child means a person below the age of 18 years. That means not attained the age of 18 years is the definition given. That means the child, earlier the Children Act and Juvenile Justice Act, the child age was different. But now it is made in consonance with this enactment. Almost all the provisions of Indian Penal Code, Indian Evidence Act, and as well the Juvenile Justice Act were brought in consonance with together. Now the present age of a minor or present age of a child is recognized as below the age of 18 years. So a lot of questions arose with reference to the age of the child, how it should be determined. If you go through the enactment very meticulously, there is no special procedure contemplated for the purpose of determining the age of the child, except under section 34(2) of POCSO Act. There is no definition as such or meticulous procedure contemplated. But under the Juvenile Justice Act, under section 94, read with rule 12 subclass 3 of Juvenile Justice Rules, which provides a detailed procedure to ascertain the age of the juvenile therein. So juvenile, who is a juvenile? Juvenile is also defined as a person who is in conflict with law, whose age is below the age of 18 years. So therefore, victim in POCSO Act is also almost stands on the same footing as that of a juvenile definition, except the word conflict with law. So therefore, the procedure which is contemplated under section 94 of Juvenile Justice Act, and as well the rules provided under rule 12 of the Juvenile Justice Rule, that can be made use of for the purpose of ascertaining the age of the victim child defined under this particular enactment. So what section 34(2) and what section 94 and what rule 12 says that? Section 34(2) provides a power to the special court for the purpose of determining the age. There in Juvenile Justice Act, Juvenile Justice Board and Juvenile Justice Sessions Court are different. Juvenile Justice Board cannot determine the age there, but it is the Sessions Court which determines the age of the juvenile therein. So far as this enactment is concerned, section 34 is the prescription given. A prescribed officer is the special court which has to decide the age. That is, the special court which deals with the matter itself has got absolute power to decide the age of the victim before it. Section 94 and rule 12 says that how the age of the child has to be determined. So there it is said under rule 12 that the competent authority, that means the investigating officer or the special court, however, whatever may be the case, arises, because a private complaint can also be filed before the special court. In that eventuality, if cognizance is taken by that court, the court itself will inquire into the matter in order to ascertain the age of the child, wherein the matter is referred to investigation either under section 156 subclass 3, or if a case is registered under section 154 of Criminal Procedure Code, the police will get an absolute power to investigate the matter and collect the material with reference to the age of the victim. So here one should bear in mind that the Supreme Court has clarified, see, though far as this aspect is concerned, that when there is no provision under this particular enactment POCSO Act, and almost Juvenile Justice Act also stands on the same footing, therefore the procedure which is adopted by the POCSO Court for the purpose of determining the age of the victim, applying the procedural aspects on par with, though section 12 we are not specifically saying, But we are taking the species into consideration for the purpose of ascertaining the age of the victim hearing. Therefore, there what section rule 12 says that the certificate issued by the competent authority with reference to the birth certificate of the child and school certificate, school leaving certificate issued by the competent authorities, or the matriculation certificate issued by the competent authorities, or any other school records or any other public documents which establishes the age of the victim, that has to be collected by the investigating officer and to be produced before the court during the filing of the charge sheet. So if these three things are not available, if no public document is available in order to establish the age of the child, then only the investigating officer or the court has to take the recourse for the medical examination of the child in order to ascertain the age of the child. So one more aspect is to be taken into consideration, whether under the Juvenile Justice Act, the physical appearance of the child can also be taken into consideration by the judge for the purpose of ascertaining the age of the child when there is no other materials are available to the court except the medical report, no other certificates or public documents are available. In such circumstances, the court has vested with the discretion to look at the physical appearance of the child and determine that the child was a minor. It should not be vice versa can be used to say that the child was adult. See the beauty of this power entrusted to the court, entrusted to the juvenile justice determination age, that the judge has got power to say only that on physical appearance he appears to be a minor, but vice versa he cannot say by using this power that the physical appearance of the child appears to be adult. Only one view is available, one opinion is available, which is in favor of the child. That is what we say, it is child-friendly opinion of the judge. So then, if all these certificates are not available, in such an eventuality, a board has to be constituted for the purpose of ascertaining the age of the particular victim or the juvenile, which is consisting of the district surgeon and others in the district or in the medical board constituted by the government at the state level. So that will decide what is the exact age of the victim. Medical report is always not conclusive in nature. So far as the courts have held that more authenticity should be given to the records which are produced by the investigating agency or before the court, which are issued by the competent authorities, which are called as public documents. This has been very well considered by the apex court in Jarnail Singh versus State in AIR 2013 Supreme Court, page 3467, and in State of Madhya Pradesh versus Anup Singh 2015 7 SCC page 773. Certificates issued by the competent authority regarding age has to be primarily relied upon by the court. And finally, in Mahadev versus State of Maharashtra 2013 14 SCC page 637, and Shahnawaz versus State of Uttar Pradesh 2011 13 SCC page 751. A procedure to be adopted by the courts and the investigating agency in ascertaining the age of the victim has been in detail dealt with in these decisions. In one of the decisions earlier to the enactment of this POCSO Act, even in proof of age, so far as offences under section 376, 377 and other offences under section 363, 366, 366A, so on, which are referable to the children to some extent, the Supreme Court has laid down certain principles as to how to prove the documents, though they are public documents, which are produced before the court. In Biradmal Sighvi versus Anand Purohit, AIR 1988 Supreme Court, page 1796, in detail it is discussed as to what is the veracity of the public documents and how it is to be produced and how it is to be proved. In another ruling era through Manjula, Krippendorf versus State, 2017, 15 SCC page 133. It is a very vital, important aspect has been considered by the Supreme Court in this particular case. It was argued before the Supreme Court that the age of the victim or the juvenile, whether it can be taken as the mental age of the child. How do we define the mental age of the child? A person may be aged 25 years, but the mental age may be 12 years. Or the child is aged about 12 years or 15 years, but its mental age may be of that of an adult who can foresee the consequences, everything. And in spite of that, he can think over, imagine everything as if an adult, and he can do something. So in such an eventuality, in either way, whether the mental age of the victim or the accused can be taken into consideration was the question that fell for consideration before the Supreme Court. Supreme Court said that it is the age of the child which is recognized or specified in the enactment as below the age of 18 years. There it is not used the mental age or physical age of the victim. It is the actual age of the victim that has to be determined by the court. It is not the mental age. Otherwise, it will have its own complexities in future. The accused who comes before the court, if he is a major adult member who is aged about 25 years, he may also take up the plea that my mental age is less than 15 years. I will come under the age of Juvenile Justice Act. So in this context, the Supreme Court has said that when the legislators have used the word age of the victim or age of the child has to be determined, not the mental age. Therefore, that question was answered in the negative. The Supreme Court has said that it is not the mental age of the victim or the accused is to be taken into consideration, but it is the actual age which can be determined on the basis of the procedure recognized under law has to be taken into consideration. In another decision, Jabbar versus State, 2018 SCC online, page 9327. In this particular case, the Aadhaar card was taken into consideration by the court as a public document, apart from the Rule 12, 3 subclass 1 to ABC, where it is stated that the certificates are mentioned, but here it is considered as a public document. Aadhaar card has also been taken into consideration to determine the age of the victim. The High Court has in fact confirmed that as a right path the trial court was going. So these are all the important aspects that one should bear in mind with reference to the age of the victim in the under the POCSO Act, how it is to be determined, not the mental age, it is the actual age. If the age of the victim girl is below the age of 18 years, suppose if the age of the victim is 17 and a half years, though there is no provision under the POCSO Act, but under the Juvenile Justice Act, if any doubt arises with regard to the age of the victim, 1 year relaxation is to be given on either side to give the benefit of doubt to the accused. There. So the similar provision, in fact, while I was sitting on the bench, I was adopting while for the purpose of granting or refusing bail to the accused persons who are under the caught under the POCSO Act. So therefore, when we adopt the rules under Rule 12 and Section 94, read with Section 34(2) of the POCSO Act, how to determine the age? Why not the said relaxation also should not be given to the accused? Because in various circumstances we come across, the circumstances show that it is only with mutual consent between the two persons some offences are committed due to the ignorance of law by the children, due to infatuation, due to love affair, due to even marriage, that is child marriage. All those things happen in the day-to-day life. So therefore, the court has to look into these provisions also under the Juvenile Justice Act, whether such relaxation can be given to the accused so far as the benefit of doubt is concerned. So far as chapter 2 is concerned, sexual offences against children is completely defined. There are various offences which are recognized under the enactment. Section 4 and subsequently the amendments were brought into force during the year 2019. Section 4, 5, 6 and 9 have been amended, enhancing the sentences to those offences and also incorporating some more definition to the offences or introducing some more definition to the existing offences under section 4, 5, 6 and 9. Very particularly, the sexual assault on a child below the age of 16 years. The penalty was life imprisonment. That is particularly considered that no relaxation should be considered by the government. As you know that the government has got absolute power under section 422 or 32 of the Criminal Procedure Code for the purpose of releasing the accused persons after lapse of certain years, considering their good conduct. That is with reference to the 14 years so far as the offense of murder is concerned, and heinous offences are concerned where the accused has been sentenced to undergo imprisonment for life. But this provision specifically says that the right of that government has been completely taken away. Life means remainder of life, that by means of amendment that has been brought into force. Section 6, if any offense is so serious which falls under the section 6 of the act, then the minimum period of punishment is prescribed as 20 years. And further, the death penalty can also be imposed by the court. Hitherto, prior to this amendment, no death penalty was recognized under the POCSO Act. It has come into force only after Nirbhaya's case, where the Supreme Court has dealt with in that particular case in detail with reference to the offense committed by a juvenile therein, who was so violent compared to other offenders. So therefore, the Act prescribes various imprisonment from the fine and from 6 months imprisonment up to death for various offences recognized under this particular chapter, and even under some other chapters also the offences are recognized. Section 4, penetrative sexual assault, 7 years imprisonment minimum is imposed and maximum was imprisonment for life. As I told you, section 6, death penalty can be imposed now. Section 8, 3 years minimum punishment, 5 years maximum. Aggravated sexual assault, 5 years and 7 years. 5 years is the minimum, 7 years is the maximum. Sexual harassment, section 12, 3 years, 5 years and up to 7 years for section 14(1). Using the child for pornography purpose, section 14(2), 10 years, minimum imprisonment for life. Section 14(3), rigorous imprisonment for life. Section 14(4), 6 years minimum, 8 years maximum. Section 14(5), 8 years minimum, 10 years maximum. Storage of pornography and pornographic material involving child. This has also gone into amendment during the year 2019. Section 15, 1, 2, 3 have been divided, and section particularly subclass 3, the punishment is imposed 7 years and imposing fine is also prescribed. Abatement for the offences under section 17, which is and section 18 and section 18, the provided for the offence committed, so far as 17 is concerned, half of the longest term prescribed for the offence, so far as section 18 is concerned. The failure to report or record the complaint under section 21, 6 months to 1 year and fine. Section 21, 22 is a very peculiar provision under this particular enactment, where a false complaint has been filed against a particular person. Then if it is proved during the course of the evidence that a false complaint has been lodged, then 6 months punishment to 1 year can be provided. But child complaint, if the complaint was filed by the child or evidence is given by the child cannot be punished under this particular provision of law. The debate arises whether he can be punished under any other law for the time being in force for giving false evidence before court. When this particular enactment, which is a special enactment, which says that, which has got overriding effect so far as the other enactments are concerned, whether still the other provisions of the Criminal Procedure Code under section 195 of Criminal Procedure Code and Indian Penal Code for giving false evidence, filing false affidavits, whether such provisions can be invoked against the complainant who is happened to be a victim who is below the age of 18 years is also a debatable point. According to me, why not is the question. If the child is able to understand that he is aged about 16 years or 17 years or attaining the age of 18 years, in the verge of a child attaining the age of 18 years, knowing fully well the consequences of her act if she implicate a boy who is also almost contemporaneous to her age. For example, 19 years, the boy is aged 19 years, girl is aged 17 and a half years. If a false complaint is lodged, why that girl should be left alone? Merely because she is a child. It is a debatable point. No decision has been yet rendered by the Supreme Court bar or any other high court so far as this aspect is concerned. I am yet to come across such things. But so far as this enactment is concerned, the victim's interest is safeguarded. Even if false evidence is given, a false complaint is given, child is not punishable under subclass 2 of section 22. Section 23 is also recognized, and 6 months imprisonment has been recognized under this particular provision. Chapter 3 deals with, and so far as this particular amendment is concerned, it has come into force from 5th August 2019. So please understand, the lawyers should first understand what is the magnitude of the offences which are recognized under the POCSO Act. Magnitude is so heavy. The responsibility is so heavy on the accused. Responsibility is so heavy on the counsel appearing for the accused. How to safeguard the interest of the accused in this regard if a false complaint is lodged. I will come to section 482 and 439 a little later after completing this each and every chapter, explaining what are the importance of that particular chapter. Chapter 3 deals with use of child for pornographic purposes and punishment for using child for pornographic purposes, punishment for storage of pornographic material involving the child. Section 14 and 14 again undergone an amendment in the year 2019, prescribing stringent punishment by imposing minimum punishment of 5 years if the offense is committed in such manner, and maximum punishment is 7 years. And for second offenses, 7 years punishment is prescribed. Section 15(3), 7 years punishment imprisonment is prescribed with a minimum of 5 years. This pornography amendments have been brought, giving definitions with regard to the storage of pornography, as the information technology has been introduced, and information technology definitions are also brought into force so far as this enactment is concerned, so far as this chapter is concerned. Section 16 refers to abatement of offences under chapter 4. Punishment for abatement, punishment for attempt to commit or attempt to commit an offence. As we have prescribed that what is meant by an abatement is defined. Abatement can be defined even under the Indian Penal Code. What is the abatement? Therefore, it is in addition to the definition given under the Indian Penal Code. Chapter 5 refers to procedure for reporting. This is a very important chapter which is introduced, which is nowhere we find in any other enactment like this. Indian Penal Code, Criminal Procedure Code, nowhere we find with regard to the procedure for reporting. Of course, we find some of the provisions in the Criminal Procedure Code that a public person in whose presence the offense has been committed and who is present at the time when the offense was committed, who has got information about the commission of the offense, he has to inform to the jurisdictional police. Hello? Hello?
Please.
Echo ಬರ್ತಾ ಇದೆ.
ಅದು ಪ್ರಮೋದ್ ಚಂದ್ರ ಅವರು ಆನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರು ಹೇಗೆ ಆನ್ ಆಯ್ತು ಗೊತ್ತಿಲ್ಲ. ಮ್ಯೂಟ್ ಮಾಡಿ.
ಪ್ರಮೋದ್ muted
ಮಾಡಿ.
Okay. So here this particular chapter deals with reporting of offenses and fixing the obligations. See, nowhere, though it is in the Indian Penal Code, to some extent it is punishable. But here it is specifically made obligatory on the part of certain persons who are having the responsibility to report the offenses. Who are all those persons who are responsible for reporting the offenses if it comes to their knowledge? Obligation of media, studio and photographic facilities to report the cases. Who are in the media, who are widespread in the country, there is no place where media will not go. Definitely, such offenses would immediately come to the knowledge of the media people. Media should inform the particular offense with the police, concerned police, or a special police constituted under the special enactment. If such reporting is not done under the provisions under section 19 and 20, the punishment is prescribed under section 21, punishment for failure to report or record a case. You see, two things are there in this particular provision. Punishment for failure to report, that falls under section 19 and 20. Not registering a case, not recording a case by the competent authority, by the police, special police or regular police, that is also constitute an offense under this particular provision, which is punishable under the provisions as I have quoted. It is punishable with imprisonment for 6 months up to 1 year or with fine. The punishment for false complaint or false information, which I have already referred to, and procedure for media is also defined under section 23. What is how they have to deal with the child cases and how they should not disclose the name of the child and under what circumstances they can only disclose with the permission of the court. Everything is in detail considered in order to safeguard the interest of the victim. Even under section 376 also, though there is no provision, especially under the Criminal Procedure Code or under the Indian Penal Code, we are guided by various precedents of the Apex Court. Apex Court in various cases, in Vishaka's case, for example, or in some other cases has directed the media or even the courts, directed the courts also not to disclose the name of the victim anywhere, even in their judgment. So that is the safeguard, because it is the future of that particular victim that is going to be spoiled if such information has been spread over through the media. Therefore, media people should adhere to section 23. What are the responsibilities they have to understand, how to behave with the child, how to behave with the society, how to behave with the court. That has been in detail explained in this particular provision. If they violate that particular aspect, then also they are punishable under the provision, that is 6 months punishment is prescribed even to the media people if they violate the guidelines under the provisions of this particular enactment. The identity of the victim is the prime and important aspect that has been taken care of in this particular chapter. It is obvious that not only the publication of the name, but also the identity of the victim in any other manner or identity of that particular case with reference to that victim is prohibited under this particular enactment as described by the Apex Court in various decisions. To quote Nipun Saxena versus Union of India, 2019, 2 SCC page 703, State of Punjab versus Ramdev Singh, 2004, 1 SCC page 421, Lalit Yadav versus State of Chhattisgarh, 2018, 7 SCC, page 499. Sangeeta Ben versus State of Gujarat, 2018 SCC, online, Supreme Court, 2300. And famous case, Vishaka versus State of Rajasthan, 1997, 6 SCC, page 241. So we must bear in mind, it is not only the responsibility of the media, but also the responsibility of the counsels appearing for the accused. And who are all the stakeholders in the court, it is their responsibilities to say that the character assassination of the victim should not be there throughout the proceedings or even after the proceedings are terminated, whether the accused is convicted or acquitted. Irrespective of that, it is the responsibility of all of us. That is the main intention of this particular chapter, one should bear in mind. Section 22, as we have referred to, whether Section 22 subclass 2 makes a discrimination with reference to the child involved in this particular case. Discrimination in the sense what, according to me, that as I told you that, of course, the mental age of the victim shall not be taken into consideration. But if a juvenile commits an offense, this provision refers to false complaint or false information given under this particular enactment. Who is going to suffer? The accused is going to suffer, and how his interest should be safeguarded. If this were to be allowed, because it is not challenged, it is there on the statute book, we have to adhere to that unless it is challenged and said to be ultra vires by the apex court. What view that the Supreme Court may take, we don't know. But yet it is not yet challenged. So either whether it amounts to discrimination between the accused and the victim. As I told you that the victim may be aged about 17 and a half or nearing to 18 years. Boy is also 19 years. The character assassination is equal to both. If a false complaint is lodged knowing fully well the consequences, why the victim should not be punished if the court is of the opinion that consciously the victim has given a false complaint against the accused person. Or in various cases you might have come across. I also, as a district judge and as well as the High Court judge, I have come across various complaints which are later compromised between the two parties. They have got married with each other. They went together without knowing the consequences of the enactment. Due to infatuation, love affair, they go together and live together as husband and wife for so many years. And in various cases, they begat children. Some NGO caught hold them and an offense has been, the case has been investigated and charge sheet has been filed. Who is going to suffer under those circumstances? Or if due to vengeance, in order to avoid the unnecessary complications and the marriage of the child, the father and mother of the victim may venture upon to file a false complaint against the boys. So in such circumstances, whether it is a discrimination, amounts to discrimination, is the question that has to be kept open to be challenged before the apex court. Why not in certain circumstances where it is proved that it is a frivolous case, deliberately done by the victim, knowing fully well all the consequences of the act. So that is again kept open to be debated by the learned counsels in this regard. And in this regard, the victim should not be punished is recognized in Tikaram and others versus State of Maharashtra, AR 1979, Supreme Court, page 185, with reference to the earlier enactments in earlier thing, how, in what manner the false information the person can be brought into books. Chapter 6 is with reference to procedure for recording the statement of a child. See, apart from we are having a separate procedure under the Criminal Procedure Code under section 164 of the code, as to how the statement of the victim has to be recorded. Under section 161 and 162, which refers to recording of the statement by the investigating agency. Apart from that, the amendment has been brought to section 154 also, Criminal Procedure Code, and as well as 164, subclass 5, how the statement of the victim shall be recorded by the police, and where it should be recorded, when it should be recorded, how it should be recorded. Everything is stated under this particular provision. Recording of the statement by the magistrate under section 164, how it should be done. It should not be in an ordinary manner as prescribed under section 164. It should be in a in-camera proceedings, child-friendly, and child should be made to understand, and it should not be under any fear. The magistrate has to disclose everything so as to bring it, he should console first to bring it to the stage that the child is giving the statement with free mind. So all those safeguards have to be taken into consideration by the magistrate while recording the statement under section 164. The police also should not record the statement in an ordinary manner under section 161 or 162. They should go to the child. They should go to the residence of the child or the place where the child is available with the consent of its parents, or the child has got trust with any other person. In presence of that man, the victim's statement has to be recorded by the police. And if necessary, it should be recorded, videographed for the purpose of the future conduct of the investigators, to show the conduct of the investigating officer. Further, even the court also should record it, videographed in a closed court, that is in a in-camera proceedings. The evidence statement have to be recorded. These are all the additional provisions regarding statement to be recorded. The parent should be present, or the person who is having, the child is having any trust with any person if the parents are not available, any guardian, any person, the child reposes trust in such person should be made available, present in that particular circumstance. If the child is unable to understand the questions that may be put to it by the police officer or by the court, an educator should be there or interpreter should be selected. These are all the mandatory provisions which the court and as well as the investigating officer should follow. And the medical examination of the child is a must. Of course, now CRPC is also brought in consonance. Even there also, it is provided that the examination of the victim and even examination of the medical examination of the accused is also a must under the enactments. So here, so far as these necessary amendments were also brought to Criminal Procedure Code regarding medical examination and regarding the examination of the accused. The medical examination, the investigating officer or the court should take care that if the child is a female, it should be by a lady medical officer, or it should be in the presence of a woman. The examination has to be done. So this chapter takes care of the special procedure with regard to the recording of the evidence, in addition statement in addition to the procedure contemplated under the Criminal Procedure Code. Chapter 8D7 deals with the special courts. As I told you that special courts are constituted for speedy remedy, speedy disposal of the cases. And even the enactment itself says that the particular case has been disposed of within a particular span of time. Therefore, in order to attain the objectives of this particular enactment, the state government and the central government have to designate the special courts. Normally, it is said that the special court, no other cases should be entrusted to the special court. POCSO or court should deal with only POCSO cases. No other responsibility should be entrusted to that court, so as to enable that court to give speedy remedy to the victim and as well as to the accused. The other provisions under this chapter is really a boon to the victims, and it is rather an antidote to the accused persons. Section 29 and 30, if you see, presumption as to certain offences, presumption of culpable mental state. See, what is meant by presumption, we have to understand. If one fact is proved, one fact is in existence, it will allow the court to presume some other fact even if it is not in existence. Suppose if the presumption as to certain offences, under this section, there are certain provisions which is stated that if once the prosecution accused is prosecuted, it should be presumed that the accused is guilty of that offense. You see the magnitude of this provision. My knowledge goes that the prosecution commences from the date when the court takes cognizance. After filing of the charge sheet, when the court takes cognizance, the prosecution begins, or at least it begins from the date of framing of charge. Either of the case, let us take even for the worst, at the time of framing of the charge. If once the charge is framed or the cognizance is taken by the court, if the court presumes that the accused is guilty of certain offences mentioned in that particular provision, is there any necessity for the prosecution to prove those cases, provisions, once again by leading evidence? This is again a question of debate. It is again a question of debate, because once you say that the offense guilt is presumed, once the cognizance is taken or charge is framed, the burden virtually by virtue of this provision shifts on to the accused to prove the contrary. But this provision is to be understood, according to me, though there are divergent opinions so far as this aspect is concerned. But my opinion is that the constitutional right under Article 21 of the Constitution prevails over all the enactments, because all the enactments emanate from the Constitution only. That is the basic structure or skeleton of all the laws. So therefore, once you say that constitutional liberty under Article 21 is there, which is made that no person shall be punished unless the procedure established by law is followed. So therefore, what is the procedure established by general law for the purpose of proving a case against the accused? So therefore, in my opinion, whether the cognizance is taken or the charges are framed, still it is the duty of the court, prosecution, to prove the guilt of the accused beyond reasonable doubt. It is only a tentative presumption that can be drawn in favor of the prosecution at the time when the cognizance is taken and the charges are framed. It is still a debatable point, as I told you, that once you draw the presumption that accused is guilty, where is the question of prosecution leading the evidence? That offense is presumed, guilt is presumed. Directly the court can proceed to call upon the accused to lead evidence, if this were to be the correct application. Because my interpretation is that Article 21 is above all the provisions or statutory provisions. Therefore, Article 21 prevails even in spite of this presumption. At least basic minimum facts had to be placed before the court by the prosecution so as to enable the accused. Because what is evidence under the Indian Evidence Act? That we have to bear in mind. What the court allows the parties to produce before the court, what the court requires before the court, that becomes evidence. So 161 statements cannot be a substantive evidence. 161 statement, they themselves will not automatically become evidence before the court. Therefore, the basic evidence that has to be adduced by the prosecution in order to prove the case beyond reasonable doubt. But till that point of time, the prima facie, the presumption is in favor of the victim. Presumption is in favor of the prosecution under these two provisions, with reference to commission of the offense, with regard to the mental state. That is very important. Mental state, intention of the parties to commit to that offense. that mental state was there in the mind of the accused, that is also presumed. Intention of the accused is also presumed. Culpability is also presumed. So this presumption is causing very lot of damage so far as the accused persons are concerned. Damage not only though innocent persons are charged, innocent persons are prosecuted, but because of this presumption, they cannot wriggle out from the case. Easily they cannot wriggle out from the case unless they prove the contrary before the court, that it is a false case or the prosecution has not proved the case beyond reasonable doubt. Because once the evidence is led, presumption has to be tested by the court by means of other evidence available on record, whether the same has been rebutted or not. So that is the dangerous attitude, dangerous provisions in this particular enactment. But in order to safeguard the interests of the victims, because the legislators found that most of the cases, if these presumptions are not there, the general provisions of bail is applicable and the other general provisions are applicable. The accused may easily wriggle out from the provisions of this particular enactment. Therefore, these stringent provisions have been incorporated in the section. So application of the code 1973 has been made available to this particular enactment also, so far as the procedural aspects are concerned. Criminal Procedure Code times is also a substantive law. So far as bail provisions is concerned, it is a substantive law. Though discretion vests with the court, the right is vested with the accused person to file the bail petition. Filing the bail petition is a right. Consideration of the bail petition is discretionary. So that is how the right of the party is restored. Though in various other enactments like Atrocities Act, the bail provision section 438 is taken away. But that is not done under this particular enactment. So therefore, all the provisions of bail and all the consideration, so far as bail petitions are concerned, are still vested with the discretion of the court, but inclusive of consideration of these presumptions recognized under this particular enactment. So in this context, the special public prosecutors have to be appointed. So one thing also to be borne in mind, that under section 301 of Criminal Procedure Code, a special counsel can also be appointed by the victim. But there is no distinction between the special public prosecutor and the counsel appointed by the victim. There is a distinction. A special public prosecutor is act as a public prosecutor in any other case, only for the purpose of speedy disposal of the cases and fast assistance to the court and concentration to the particular nature of cases. Special public prosecutors are recognized and appointed under this particular enactment. Otherwise, the role of the public prosecutor is one and the same. So far as the counsels who are appointed by the victim under section 301 of Criminal Procedure Code, the procedure contemplated under section 301 is also same. No special procedure giving fullest power to the counsel appointed by the victim to supersede the public prosecutor. That is not there. That is not there. Therefore, the special counsel appointed by the victim can only assist the public prosecutor, and he cannot have an independent voice before the court. That is what is recognized under section 301 of Criminal Procedure Code. So therefore, this particular provision takes care of the interest of the victims, and they will safeguard the interest of the victims until the case is proved to be false or not proved by the prosecution beyond reasonable doubt. Till that particular point of time, the presumption goes in favor of the prosecutions. The next chapter is chapter 8, and procedure and powers of the special courts in recording the evidence. As I told you, that the special court itself clearly discloses, its name itself discloses that it is special in nature. The procedure and the powers of the court, special court, is defined under section 33. Determination of the age by the special court, as I have told you, is contemplated under section 34. There in the Juvenile Justice Act, not the board can decide the age, though it can try the juvenile offender, but the sessions court has to decide the age of the juvenile in that particular case. The period for recording of the evidence of the child and disposal of the case is specified in the enactment. In some of the cases, it is argued before the court that the section 35 is prescribed because of the presumptions under section 29 and 30. Normally, the accused may not get bail. Therefore, in order to prove the case against the accused or the accused established that he is not guilty of the offense, the speedy remedy is provided not only to the victim, but also to the accused under section 35. That one should bear in mind. Our High Court has held that merely because this procedure has not been followed by the courts, it will not ipso facto enable the accused to enlarge himself on bail. It is only a procedural irregularity, not an illegality committed by the court, depending upon the load of the court, depending on the nature of the case, depending upon the volume of the case and witnesses involved in that particular case. If at all the case cannot be decided within that particular span of time, the accused is not automatically entitled for grant of bail. That has been considered by our High Court. The child not to see the accused at the time of testifying. That is why in-camera proceedings. Nowadays, the rules or guidelines have been issued by the High Court that as to how the child witness have to be brought to the court. And it should be from a separate door. Normally, the litigants will enter the court in the main door, but child witness will not normally enter the court in that door. A separate door has to be done and separate room has to be kept to keep the victim in that particular area, not to allow any other person's litigant to mingle with the child, and directly it should go to the court, inside the court, and normally it is not to the open court, but it is to the special room which is constituted for the purpose of recording the evidence of the victim. These are all the safeguards that have been taken by the Child Welfare Committee constituted by the High Court. They are issuing guidelines even while constructing the building of the court, that care has been taken so far as to create a particular room or fix a particular room for the recording of the statement of the victim. And particularly, the court should take care that it should not see the face of the accused. Accused can see the victim inside the box with the semi-transparent glass covered into the victim witness box, and he can look into, but she cannot look into the accused. What is going on can be seen by the accused, but the victim cannot see outside whether accused is present or not, whether accused is seeing her or not. She is totally secluded from that particular place. Trials to be conducted in camera. In camera in the sense, not normally in the open court. Even it can be in the chambers of the judge, or it should be inside the court, open court, sending all the persons outside except the child witness and the person, the parents, or the person who is having, the child has trust with that particular person, to enable the child to feel free to depose before the court. Assistance of interpreter and expert while recording the evidence of the child should be taken if the child is unable to understand the questions that may be put to it due to fear or due to any other reason, or the child may give the answers in the manner of sign or in any other manner, so that make it intelligible. The court has to adopt the procedure contemplated under this particular provision. So the Karnataka High Court has, as I told you, that merely the procedure being not followed, it is not automatic that the accused is entitled for bail. Vinay versus State of Karnataka, 2017, 5 Karnataka Law Journal, page 479. This has been considered by by our High Court. So here, one thing is to be looked into. If suppose these procedures are not followed, what is to be done is not stated in the enactment again. If the judge has not followed the procedure, if he gives explanation, of course, there is separate channel is there to the High Court through vigilance to inquire into the matter about the judge, whether it has been deliberately done or due to any pressure of work it has not been done, etc. And so as the other provisions are concerned, if it is violated, no punishment is prescribed under this particular provision, particularly so far as this chapter is concerned. Because as I told you that the High Court is having fullest power so far as all the trial courts are concerned. It can take appropriate action on the administrative. So that may be perhaps the reason the legislators have not incorporated any punitive provision so far as these aspects are concerned. The last but not least, the 9th chapter deals with miscellaneous, that they empowers the government to formulate guidelines for child to take assistance of experts, right of child to take assistance of legal practitioner, provisions of section 3 to 13 not to apply in certain cases. This is also another important provision one should bear in mind, because these provisions, if a doctor or any other person who is authorized to examine the child, in such circumstances, he has to touch the private part of the victim, or he has to do the examination of various parts of the victim, the doctor. If otherwise than this provision, the other provisions will attract. If he touches the private part of the victim, the doctor, if this exception is not there, it becomes an offense. If any complaint is made, or even if no complaint is made, if it is brought to the notice of the competent authorities like police or the court, it is defined an offense. Such type of offense is already defined. Even a person touches the private part, that becomes an offense. So therefore, an exclusive clause is there. Provisions of section 3 to 13 not to apply in certain cases. What are those cases? Is also defined in that particular provision. Another provision important in this chapter is alternative punishment. Alternative punishment in the sense that if the offense fall under the POCSO Act, which is almost similar, and similar definition is also there in the Indian Penal Code or any other law for the time being in force. In this particular provision, so many provisions are quoted under section 376, A to G, etc. Those provisions are committed, which is the highest magnitude of the punishment that can be given comparatively the POCSO Act and as well as the Indian Penal Code. That highest punishment has to be given if the definition or embraces with each other and almost the offense is same, and which offense is more in the degree and which punishment is more in which law, that alternative punishment has to be given. So this is also another important aspect should be borne in mind by the advocates, that merely because POCSO Act prescribes a lesser punishment, it doesn't mean to say the court cannot award more punishment if for the same definition, same offense, same type of offense, the more punishment is prescribed under the Indian Penal Code. Section 43 and 44, 45 and 46 are the important aspects that should be taken into consideration by various other departments like Legal Services Authority. Public awareness about the enactment, monitoring of implementation of the Act, power to make rules. Rules have already been in vogue right from 2012 itself. Rules have been framed, and further in the year 2020, the rules have been substituted, rather repealing of the rule has been done, and 2020 rules are in vogue now, which has already came into force from 9/3 to 2020. But one precarious important aspect I have observed in these rules, though the Supreme Court has said that for the purpose of determining the age, certain procedures are followed under Rule 12 of Juvenile Justice Rules. They would have reiterated the same under these rules. but the legislators have not introduced any separate rule, even in 2020 rules, with regard to the determination of the age. Perhaps they might have felt that those rules, Juvenile Justice Act, which has been recognized by the Supreme Court, that can be adopted, holds good even for the ascertainment of the age under this act also. So therefore, with these alternative punishments, the one should bear in mind that the alternative punishment always, if it is higher, that can be imposed. So the advocate should take care what is the definition of the offense under the POCSO Act, whether it intertwines with the other offense under the Indian Penal Code. Then which punishment is more? So what is the requirement of law so far as that section is concerned and this section is concerned? What is the nature of proof is required, etc., has to be borne in mind by the council. So the awareness of the enactment, in my opinion, the awareness is not so much. The stakeholders are not awakened yet. See, the rare case, the cases which are appearing before the court are almost, the offender is between the age of 18 to 25, and the victim is between the age of 15 to 17 and half or 18 years. So the stakeholders are morely teenagers. Teenagers are the stakeholders. So therefore, they must be made aware of the provisions of this particular enactment. What is the consequences of their mutual understanding, their love affair, they're going together without intimating the father and mother, living together as husband and wife or as lovers, and enjoy sex and come back. Thereafter, the boy was caught. His life is ruined. Who is responsible for all these things? So if the awareness is created, lawyers are also responsible for creating the awareness in these stakeholders. The parents should be, awareness should be created in the parents. They have to guide the children in proper manner. The POCSO Act has to be dealt with, how stringently it is dealt with. What is the presumption available? If the person is caught under the Act, how he cannot easily wriggle out from the enactment? How he is not easily entitled for bail? Everything, it should be within the knowledge of at least these teenagers and the young community of our country, whether it is a boy or a girl, the future of our country. They are the children, are the future of our country. It is not only to safeguard the victim, but also to safeguard the accused person, because the constitutional mandate under Article 21 of the Constitution, it is equally applicable. We have not only to safeguard the interest of the victim, but also, as far as possible, within the four corners of law, the interest of the accused also. So therefore, the new amendment, one more amendment is coming. Section 2020, it is already proposed. It is passed in Rajya Sabha. I don't know whether it is passed in Parliament or not. Whether it is placed before tables before the Lok Sabha or not. They want to reduce the age of the accused from the juvenile also, from 15 onwards. That is between 15 and 18 years. If the boy has committed an offense, though he is a juvenile, he should be treated as an adult for the purpose of this particular enactment. This has been perhaps considered on the basis of Nirbhaya's case, because in that particular case, in the 2017 6th SCC page 1, Nirbhaya's case, the juvenile involved in that particular case was so violent considered to other offenders in that particular case. He was more violent. So therefore, perhaps that made the legislators, parliamentarians, to still amend the, it is not yet got the president's assent or not yet placed before the Lok Sabha, I think. And the explanation given for the purpose of introducing section 18A. Section 18A says that notwithstanding anything contained in any other law for the time being in force, where a child commits, you see, child commits, juvenile commits, or attempts to commit any offense punishable under this act, or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense, he shall be charged as adult for such offense and shall be liable for punishment under this act. So from 15 onwards, 15 years to 18 years, the relaxation is given, and from 15 years onwards itself, he should be treated as an adult. The child explanation given in the amendment is that child means any person between 15 and 18 years of age. So therefore, this is another important aspect. It is yet to be passed by the Parliament. If that is passed, even juvenile offenders from who are aged between 15 and 18 are also caught under this act. In respect of bails, I have already told you that it is a very stringent enactment. Of course, in view of these presumptions under section 29 and 30, you look at the provisions of some other enactment like Forest Act and NDPS Act. Bail provisions are separately made there. Here, separate bail provisions are not contemplated under the Act. But Criminal Procedure Code is made applicable. All the provisions of Criminal Procedure Code are applicable. In addition to that, some procedures contemplated under the Act are also applicable. So if you say that Criminal Procedure Code is applicable, all the provisions are bail or ipso facto applicable. There is no exception. 438 is not taken away. When such being the case, the presumption has to be taken into consideration while the courts are dealing with the provisions of bails. So under section 37 of the NDPS Act and under the Forest Act also, where it is allegations are there against the accused, which constitute the offense under those provisions, then prima facie the guilt has to be presumed by the court unless the contrary is shown by the court at the time of considering the bail petition that he is not guilty. So in the same fashion, the court has to consider the bail petitions under the POCSO Act also. Because though there is no special provision, but in view of section 29 and 30, certain provisions which are attracted, invoked by the police, which the court can draw the presumptions in such circumstances when the court presumes the guilt, presumes the mental attitude of the accused. In such circumstances, in the course of the bail petition, during the course of arguing the matter, the counsel for the accused should show to the court that accused is not guilty on the basis of the records at the initial stages itself. That is the reason why the courts normally will not allow the bail petitions because of these stringent provisions. But if you are able to show that the probability is there in the case on record itself, that on the materials collected by the police themselves, or the material collected during the course of inquiry by the court itself in a private complaint, that the presumption cannot be drawn. Under what circumstances? If allegations, even read as it is, it may not constitute the offenses invoked by the police. It may not constitute some of the offenses. Doubt arises. In such circumstances, the court's discretionary power, when it is not taken away, the discretion can be exercised by the courts while dealing with the bail petitions. These are all the two important aspects considered by the court in two decisions. Jailakshmipuram Police versus N. Shivabasavanna alias Basava, 2016 bracket 3 Karnataka Law Journal, where the court has considered section 29. If sufficient materials are not there, accused is entitled for even anticipatory bail. In another ruling, contrary view has been taken. 2014 bracket 3 Karnataka Law Journal, page 251. Vinod Kumar versus State, 2014 bracket 5 Karnataka Law Journal, page 81. In these two decisions, the court has considered the age and as well as the circumstances, whether the bail can be granted or not is discussed. The bail can also be granted on the basis of changed circumstances. The presumption when can be rebutted? when contrary evidence is available, which probabilizes the case of the accused. That is the view always the courts are taking. That means if the witnesses, all the witnesses have turned hostile, and the prosecution evidence and the evidence of the case is complete, one should understand this. In so many cases I have come across, even victim has turned hostile, not yet cross-examined. Parents of the victim, not yet examined. And medical officer, not yet examined. In such circumstances, only on the basis of the victim evidence completed, the examination chief, they come to the court for grant of bail as a changed circumstance. So in so many cases, the court has rejected the bail, stating that it is not a changed, not a complete changed circumstance. But changed circumstance also enable the accused to seek for bail. So this has been considered by the court in Shakti Velu versus State of Karnataka in criminal petition number 9772/2017 dated 16/1/2018. Supreme Court also said in various decisions that any number of bail petitions can be filed at any stage of the proceedings with changed circumstances, which the court has to examine whether the materials available probabilizes the case of the accused. Probabilizes the case of the accused. If the doubt is created, that is sufficient for grant of bail. So far as section 482 of Criminal Procedure Code is concerned, this is the last segment of this lecture, rather discussion, that section 482 is a very wonderful provision, which in almost all the cases, they are invoked right from the day of registration of a case till the case is decided. On all these stages of the cases, 482 is applicable. But so far as the POCSO Act is concerned, in view of the presumption available under section 29 and 30, normally the court will not exercise the powers under section 482 Criminal Procedure Code. But if the ingredients of the offense itself is not there, if prima facie it is available that it is only due to vengeance that case has been foisted and no legal requirement, if any, has been fulfilled or followed by the investigating officer, and the complaint has been filed with a malicious intention, etc. If it is available conclusively, you must bear in mind that the court should conclusively come to the conclusion, yes, it is a malicious case, it is a false case, it is only due to vengeance the case has been registered. So this normally the court will look into that without giving opportunity to the other side, whether vengeance can be tested at the initial stage itself. So therefore 482 on the ground of vengeance, it is very difficult to prove at the initial stages. By means of production of additional evidence that may be established in certain cases, the Supreme Court also said that those materials available or additional material produced by the accused before the court are of a sterling quality, which are nothing but admitted facts or proved facts, which nobody can challenge that. In such circumstances only, the court very rarely interfere with the investigation, rarely interfere with the court proceedings in order to quash the proceedings. As you are all very well know about Bhajanlal's case, Bhajanlal versus State of the state in 1992, supplement page 1, SCC page 335, where the parameters have been, guidelines have been laid down by the Supreme Court, which is even as on today, even followed by the Supreme Court itself in the latest cases, that is in Vineet Kumar versus State of Uttar Pradesh, 2017, bracket 13 SCC page 369, and in criminal appeal number 138 of 2020 by the Supreme Court, judgment dated 31/2020 between Ahmad Ali Qureshi versus State of Uttar Pradesh, the Supreme Court has considered that the principles laid down or guidelines laid down in Bhajanlal's case is equally applicable to POCSO Act also. But those guidelines have to be very strictly proved before the court. Then only 482 can also be invoked. There is no bar, because in toto Criminal Procedure Code is applicable for so far as the procedures are concerned. Even it includes the POCSO Act. The Apex Court has also taken into consideration, and our court also taken into consideration, if compromise between the parties, whether it will enable the court to quash the proceedings or enable the court to grant the bail. So in two decisions, in Soni Nihal Dinesh Bhai and another versus Sandeep Patel and another, 2017, bracket 3, Karnataka Law Journal, page 82, and Jaiprakash Narayan versus State of Karnataka, 2018, bracket 6, Karnataka Law Journal, 662. In these cases, the compromise between the parties is no ground for granting bail, or compromise between the parties is no ground for the purpose of quashing the proceedings, because it is said that it is not the offense against the victim, but it is against the state itself or against the society. Therefore, it should be very carefully considered. Even the Supreme Court, in one of the cases, Justice Deepak Mishra, it is arising out of the Madras High Court, where compromise has been entered into between the parties. Supreme Court said that compromise will not erase the offense committed by the accused. Therefore, he should be tried. And during the course of evidence, if she turns hostile, by means of appreciation of evidence only, if the accused is really entitled for acquittal, he should be acquitted. Otherwise, no interference with reference to the compromise, even if it is entered to, and quashing of the proceedings should be very rarely done. So that is with regard to the important aspects, the salient features and the present scenario of the POCSO Act. In the year 2019, the Supreme Court, in a decision between Ravi versus State of Maharashtra, 2019 within brackets 9 SCC, page 622, it held that 2019 amendment is constitutionally valid by prescribing death penalty to section 6 of the POCSO Act. Death penalty, which is to be given in rarest of rare case, though the dissenting view is expressed by one of the judges, but majority view is that the amendment brought to the POCSO Act, though it is so harsh, death penalty is so harsh, in a rarest of rare case it has to be given. Therefore, it is held that it is constitutionally valid. With this, I thank once again the organizers for having provided me this opportunity. If I have overshooted the time, please kindly excuse me. And if there is any questions, if I know the answer, I will give you, otherwise I will give you later. The session is open now.
Thank you, sir, for an extremely erudite and very comprehensive presentation. Thank you so much. Now we shall proceed to the Q&A session. I see Mr. Joe Joseph raising his hand. Yes, I have unmuted you, sir. Quickly, you may pose your question. But due to paucity of time, we'll be picking up very few questions. Let me make it very clear. Sir, I have unmuted you.
Okay.
Yes. Sir, you are not, you will have to unmute yourself. I have given you the option.
Oh, you have given me the option.
No, sir, no, sir. It is for the speaker, for the person who was asking the question. Yeah. I will be unmuting you, sir. 1 second, sir. Our honorable speaker is muted. Sir, I have unmuted you now.
Good evening, sir. Joe here. Can you hear me, sir?
Sir, 1 second. Our honorable speaker is muted. Sir, I have given you unmute option. You'll have to unmute yourself, sir.
Okay, I have unmuted.
Good evening, sir. Joe here. Can you hear me, sir?
Yes, Mr. Joe. I'm hearing you and seeing you.
Oh, thank you very much, sir. Thank you.
Yes.
Nice to hear you.
Yes, please.
Sir, in one of the cases that came for the mediation,
yes,
there is a WP, domestic violence,
yes,
divorce petition, yes. 125, and a JNWC. So after all this, there was harassment to the boys' side and both the sides as such. They filed a case under POSCO.
Yes.
So they are ready to withdraw all these cases and go for the divorce petition and close all the petitions as such.
Yes.
So because POSCO was included in this, which cannot be compromised or could not be closed as such, it was sent back as no settle over there.
Okay.
And the court pardoned him in case he gives everything in writing. I will not see the child. Custody will be given to the wife. Things like that comes. Can the court pardon him, sir?
No, he cannot. The court cannot pardon him. But court, there is no question of pardoning arises. There is no question of pardon anywhere considered in any of the enactments except tender of pardon. You see, so pardoning is nowhere there. But the court, if it minds that it is arising or it is the offshoot of other cases, if the 482 petition is concerned, if it is filed, the POXO proceeding, that is why I told you that the powers of the court under section 482 is not taken away. Is not taken away. If it is established before the court that it is a false case is foisted and it is in the nature of a conclusive proof to the satisfaction of the court it is given, at the most the court can quash the proceedings so far as the POXO proceedings are concerned. Where the other matters which are compoundable, the parties can withdraw or compound the offences. Where it is not compoundable, like POXO Act, they have to approach the High Court under section 482, making it clear that there is no list actually pending and everything is compromised and it will cause inconvenience to them in future. Therefore, the court may take lenient view and quash the proceedings.
Thank you, sir. Thank you very much.
Right.
Thank you, sir. Mr. Anand has a question. I have unmuted you, Mr. Anand. Joe, sir, I request you to mute yourself.
Yeah, I do.
Hello, sir. You are able to hear me?
You're not very audible, Mr. Anand.
Hello, sir. You are able to hear me?
Yes,
Very
Mr. Anand.
feeble. Please go ahead.
Yeah. So this is regarding on section 22, the punishment of filing a false complaint.
Yes.
So now the question for me before you is, sir, what if I file a direct PCR or the respective jurisdictional magistrate, which is a special court, whether this 154(3) of a CRPC will come into the picture in consequences of a 2016 judgment of Priyanka Srivastav. So subsequently, now the complaint will be filed by normally victim mother or a father. So whether this under 18, where in a special enactment has been given as provision under 18 of a child, where there is no, nowhere the punishment would be given to the child if there is a child age is on below 18 years. So keeping up these scenarios, so whether the victim mother who is a first informant would can be convicted if at all if the defense plea has been taken in the initial stage.
Definitely. Only the exclusion is the child under section 22(2). If any other person, because the reason is this, the child may understand, may not understand. The presumption is child will not understand. The child will not understand what is the consequences of its act. Therefore, the child is exempted under section 22 subclass 2. But so far as the others adult members are concerned, the presumption is otherwise. Presumption is that knowing fully well the consequences, they have filed the complaint. If it is proved to be false, the others can be punished. One thing. The second, so far as 156 subclass 3 is concerned, Priyanka case is no exception to POXO Act. There under section 200, if the complaint is filed, there are two options open to the court. One is the court itself can take cognizance and inquire into the matter. And if necessary, it can refer the complaint under section 202 for investigation and report. That will not fall under section 156 subclass 3. It will only fall under section 202. Then 156 Priyanka case will not come in the way. If the magistrate refers the matter or special court refers the matter for investigation under section 156 subclass 3, Priyanka case will come into picture. The question arises why the complainant has not lodged the complaint before the police and why it has not been brought to the notice of the superintendent of police and what action has been taken. Affidavit has to be filed, even there is no exception so far as that aspect is concerned.
So in a present scenario, we can directly go and file a PCR in the respective.
Oh, definitely. There is no bar. Special court can take cognizance.
Okay, so thank
Special
you.
court can take, not to the magistrate, it is to the special court.
Yeah, special court. Yeah, understood.
Oh, okay,
Thank
right.
Thank you, sir. We have Mr. KB Manish Kumar. Sir, I have unmuted you. Very quickly, you can pose your question.
My lords, I just wanted the judgment, my lords, Jailakshmipuram police station, my lords, versus NS 2016 KLJ. I couldn't write it down.
ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ಅದರಲ್ಲಿ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಕೇಳಿ ಅದರಲ್ಲಿ?
ಅಲ್ಲ, ಆ ಜಜ್ಮೆಂಟ್ ಬೇಕಾಗಿತ್ತು ನನಗೆ, ಅದಕ್ಕೆ.
ನನಗೆ ನೀವು ತಗೋಬೇಕು, ನಾನು ಕೋಟ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ.
ಇಲ್ಲ, ನಾನು ಐ couldn't write it down by that time.
ಬರ್ಕೊಂಡಿಲ್ವಾ?
Later we will provide you, sir, because that would be recorded at later point of time. I will try to share it with you.
Thank you. That's all my question.
It is not a question at all.
So just a clarification.
Okay, right.
All right, do we have any more questions before we wind up today's session? Yeah, last question will take up by Mr. Harish. Yes, sir.
Yes, Mr. Harish. Where is Mr. Harish?
Yes, sir.
Yes, Mr. Harish.
Sir.
Good evening. Good evening.
Sir, as you know that lot of records can be created as far as date of birth and age proof. Lot of fraud happens in these things. In such a case, when there is a bone ossification test available for proving the age, which is scientifically accepted all over the world, in a conflict between the document, then which will prevail, sir?
The documents will prevail because it is the rule has been framed. The rule has been framed. If rule were not to be there, then any conflict arises with reference to the oral evidence and the medical evidence. Then the court has to test. Court has to set which prominence should be given to the medical evidence or the ocular evidence. But here the rule is framed. Supreme Court has said that first preference should be given to the documents. All right, if those are fake documents, or those documents are not genuine documents, if they are put into evidence, the accused has got an opportunity to prove before the court that they are not genuine documents. In such an eventuality, if the court comes to the conclusion that no reliance can be placed on such documentary evidence, then the court can switch on to the medical evidence and rely upon that and decide the case.
I have last two issues to be a quick one, sir. One is in this social activist Rehana Fatima, who engaged her two minor children to paint her semi-nude body to sexually educate and put it on the Facebook from Kerala. In this case, after the 2019 amendment of inclusion of the word child pornography, it says sexually explicit conduct involving children in a sexually explicit conduct. Will this case of Rehana Fatima will POCSO not apply to her in this case?
No, I cannot answer this case because it is already sub judice before the court. Please don't expect any answer over this aspect.
The last one is
because it is already before the court. Let the court take its decision.
Okay, sir. I got your point, sir. I got your point.
Yes.
Because there has been apprehensions in the media about her arrest under POCSO. That is why I was.
That's right. Okay.
The other one is you spoke about the mental age.
Yes.
And whereas the act says biological age is what they are going to rely upon.
Actual age.
Is it not the need of the hour? In case of mentally retarded victims of rape or a sexual assault, even if they are majors, is it not the need of the hour to bring in this mental age as a category under the POCSO? Because they will definitely be similar to a child's mental faculty.
That can be brought in by way of amendment only. By way of amendment only, it should be brought. A proposal should be there. If the parliamentarians feels that it should be incorporated, they can do that. But what the Supreme Court said that we cannot do injustice by saying that mental age should be taken into consideration. Otherwise, if the enactment doesn't permit, if the court interprets, it is virtually amounts to legislating the enactment or introducing an amendment. Therefore, Supreme Court itself has said that we leave it to the legislators.
Wisdom of the parliament.
Wisdom of the parliament.
Thank you, sir. Thank you, sir.
Okay, thank you.
Thank you, sir. With this, we have concluded the Q&A interactive session. Sir, personally, I have one question.
Yes.
What is the role of the government in educating the parents, teachers, and the students, as in once they have attained certain age, about the provision of POCSO, so that with that they could avoid happening of these offences? Is there a role on the government?
Yes. You see, it is not only the responsibility of the government. I have already told you, it is the responsibility of all the citizens of the country whoever may be, if possible, they educate each and every person who is surrounding them, whether he is an advocate or any person who knows about this particular law, whether he is a judge, lawyer, engineer, whoever he may be. That is one part. Second part is the government can take appropriate steps. Likewise, when we were young, we were studying in schools, there was moral education was there. Moral education with reference to some enactmental information was inbuilt in the moral education. Enactmental information inbuilt in the moral education. If such education is introduced, you see, protection, POXO Act is not yet even introduced to the law course. Law students do not know about the contents of the POXO Act, let alone the other students of other faculty. Law students. That is why whether it can be introduced as a curriculum in the nature of guidelines to the students, in the way of moral education or in any other manner, a subject like, if it would definitely benefit the entire society at large. Even parents will come to know about that, etc. And every educational institution should be visited by the Legal Services Authority, and they will take utmost responsibility to spread the awareness amongst all the stakeholders, particularly the teenagers.
Okay, sir.
Okay.
With this, sir, we have hit the fag end of this session. Sir, once again, on behalf of Advocates Association Bengaluru, I extend my sincere gratitude to you for today's very informative presentation. Thank you so much, sir.
Thank you very much. I am also very happy to come back to you again, and you are all still remembering me even after my retirement. Thank you very much for the opportunity. Good day to all.
Thank you, sir. With your permission, sir, now we'll be signing off today's webinar.
Okay, thank you.